22-41237 is called Catario Richard Richardson. Is that you?
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney. There is a first amended motion to revoke unadjudicated probation. Does the defendant waive a formal reading of this? Can we proceed in a summary?
Yes, sir.
In summary, this motion to revoke your probation alleges that on January 30th, 2023, earlier this year, you were placed on 10 years deferred or unadjudicated probation for aggravated assault causing serious bodily injury, a second-degree felony. Is that true?
Yes, sir.
Number one, state you failed to report to the Jefferson County Probation Office for the months of April 2023 and May of 2023 in violation of your probation order. Is that true or untrue?
Yes, sir.
Was he a absconder or did he? How long was he gone?
He only reported from his initial visit, which was March 1st of this year, and after that, he went off.
Never came back?
Never.
Is that true? The
Yes,
first
sir.
one and then that was it? You had 10 years of probation. Oh, it just wasn't convenient for you? Or
Sir.
why did you walk off the job?
I wanted to report, but at the time,
Your feet didn't want you to be there.
No, sir.
You know, that's, if there's, the one thing you have to do is report. If you don't report, you're not on
Yeah.
probation. You're not on probation. That's the only way we can supervise you. We can't, there's 5,000 probationers. We can't go out and search them and plead with them to come back. You've got a responsibility that you swore to when you were placed on probation right here. I will follow all the conditions of your
Yes, sir.
signature. I will follow all the conditions, and I know this can be revoked for any violation. All right. Just don't want you to be surprised with what happens next. Let me go to 5. You committed the offense of evading.
In a minute.
5, you committed the offense of evading detention on or about November 25th, 2023 in Jefferson County, Texas, against the peace and dignity of the state in violation of your probation order. Is that true?
Sir.
Huh?
Yes, sir.
Are you pleading true to that? Voluntarily and because it is true. You understand that one or more violations of your probation, if found true by a preponderance of the evidence or greater, or enough to revoke this probation.
Yes, sir.
Your probation
Second.
can be revoked. You can now be found guilty, and you are looking at no less than 2 nor more than 20 years confinement in prison. Plus whatever prison time you serve, you cannot be paroled until 1/2 the time of service has occurred, because there's a deadly weapon, namely a firearm, that was used in the commission of this aggravated assault. You shot somebody. Do you understand all of this?
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true to this aggravated assault motion to revoke probation, the violations under that plea of guilty that we placed you on probation. Let me look at something.
Right now, this hearing looks like a simple probation violation case, but watch closely. The judge is about to revisit the original crime, and that's where everything changes. In probation revocation hearings, Judges often look at whether the defendant deserves a second chance.
All right. I remember this. Yeah. This is terrible. Go ahead, Steph.
The whole reason why I handed you that PSI is when I look back at that original charge that we decided to give this young man an opportunity.
Attempted murder.
Yeah, it's not only that, but there's within the facts itself, there was a kidnapping that we chose not to move forward on.
Yes.
It's just a huge disappointment when you give somebody an opportunity to succeed and all they do is thumb their nose at the court and basically choose to do whatever they want to once we placed him on probation. It was only because of the count number 5 where he was arrested there that he's standing before you right now. That charge of evading detention was when we actually were able to place him in custody and have him stand accountable for the failure to do anything really on probation other than report the first time.
And there it is, the prosecution's key argument. They're not just focused on the missed probation appointments. They're reminding the court that this was originally an attempted murder case involving gunfire, a kidnapping allegation, and a victim who survived multiple gunshot wounds.
Based upon that, the state is suggesting a 10-year sentence.
He's looking at no less than 2, no more than 20, right?
Yes, sir.
What do you say?
Would you explain to the court, as you were trying to tell me earlier, your explanation for what's happened here and why you did not report?
I did want to report, but at the time, I had just recently lost my grandmother, and after that, I lost my aunt, both to cancer, and they were my main 2 supporters. So at the time, I really didn't have a support system I needed, and I tried to find work, but I couldn't. And I know I was supposed to report, but by this being my first time on papers, I really didn't know. And I am expecting a daughter on January the 8th. Like, honest to God, truth, like, I finally found a job. Like, I only worked like 2 weeks. It was like a fast food job, but I ended up coming here.
Any job is a worthy job to begin with.
I couldn't find work, and I was trying to find work.
That's not the point. The point is you didn't report, and everybody has to
Yes,
report.
I know
That's the easiest thing to do.
I know, but by this being my first time on papers, I
No,
didn't really
no,
understand.
no, sir. So, sir. No, I can tell you, you did it on your terms. You don't follow rules. This is it just needs to be read back into the record here, how disturbing this was. In the middle of the day here. Police,
So the charge that I'm on paper for?
police, yeah, don't interrupt the court. You get a chance to speak, but only one of us can speak. If we speak over each other, the court reporter can't do her job. Police, in the middle of the day here in Beaumont, are called out to the scene of a vehicle that has multiple bullet holes in the rear of the vehicle. The victim had been shot multiple times and was transported to the hospital for treatment. The victim stated while she was placing her child in her vehicle, a red Mercedes SUV occupied by you and 2 others. Don't shake your head. You're going to listen to this because this was admitted and everybody agreed this was true. You and 2 others pulled up and began to fire rounds into the vehicle. Multiple shell casings were located at the scene. And the victim, I think, was a person who was looks like they were 20 years old. How old was the child again? That was in the vehicle.
And
It says,
I thought I had the right date, Judge, but that doesn't look accurate.
I'll speak.
they were, no, I'm not through. You get to speak here.
Let me
You like
look,
to interrupt, don't you?
let me look up that detail for you, Judge.
There was, this was all in violation of a CPS order where someone was not allowed to have that child. And the child had been taken at gunpoint from her. The front passenger of the vehicle was you. You were in possession of a Taurus 9mm firearm. Apparently, the information
Right.
and the investigation confirmed that you were the shooter in this incident. And you pleaded guilty to aggravated assault causing serious bodily injury. And again, I guess it was a miracle that a little child was not killed. That somebody else was shot. Here in the middle of the day in Beaumont.
Pay attention to what's happening here. The judge isn't merely discussing paperwork anymore. He's reconstructing the original shooting in vivid detail. Why? Because sentencing is about accountability.
And what did you want to say? Go ahead.
I wanted to say that the child that was my nephew, and the only reason that I shot was because they shot at us first, and I had loved ones in the vehicle, and my nephew wasn't in the car.
What are you doing with a gun in the first place?
It was my aunt's.
No,
And I
what are you doing with a firearm, sir?
had no vehicle.
Why aren't you in school?
Sorry, Judge. Took me a minute. The child was 3.
Child was 3 years old. That would have been capital murder. That child would have been killed.
The,
You'd have had two choices: life without parole or death.
the child.
That's how. Do you understand how serious this is?
Yes, sir. But the child was nowhere in the vehicle because when we pulled up,
So that's okay to shoot around town,
no, I'm saying,
shoot a vehicle,
no, I'm
and
saying
shoot a person.
before we got shot at. The child was already in the house because the woman took the child in the house.
How far did
And
you
that's
go in
when-
school? Why weren't you in school on that day?
Because I'm not in
Huh?
school. I'm not in school every month.
Yeah, I know. Why weren't you in school on November 17th?
Because I don't attend school.
Because you don't. How far did you go in school?
11.
11, and you just quit.
Not necessarily, but you can say that.
Okay, I will. That's the way this results. I mean, in the middle of town, y'all are shooting up this town with people in cars, shooting people. A 3-year-old child was in harm's way,
It was only-
and you, number one, you shouldn't even be having a firearm. That's craziness. Number two, you don't shoot it at anybody in the middle of this town. And drive around shooting at people from vehicles. This is chaos. What's the probation office say? You're going to get a chance to speak last.
Your Honor, when I took over his case, he was already an absconder. When I visited him in the jail, now he didn't mention to me anything about the ones that he's saying are deceased. He told me that he just wasn't taking probation seriously, and now he wants to take probation seriously.
All right. Go ahead. Anything else to add by anybody? You
Anything
may
else you
speak.
want to tell the judge?
I just wanted to say, I do realize I made a mistake and,
Which time? Which mistake are you talking about? I see a bunch of mistakes.
both times, but I do want to say, if you allow me a second chance, I do want to complete papers and I will complete papers. I just, like I said, I made a mistake and I just want to do right with papers and finish it. I will finish it if I'm allowed to.
What state's asking again?
10 years, Judge.
There's a 3-year-old child involved in this, I guess is.
Yes, sir.
Could I say one thing?
Hmm.
The child, like I said, is my nephew and I would never.
Oh, so that's okay to shoot at the child?
No, like I said, it was self-defense. They shot at us.
You know, what's odd is that's not what you pleaded when you pleaded guilty. You didn't take this, you could have gone to trial. You didn't do that. You insisted on pleading guilty to this, sir.
I really didn't know how to move forward with the case because I've never been in a situation like this before.
Anything else?
No, sir.
Anything else?
This
Yes.
is the turning point.
All right, there is
Notice how the
sufficient
defendant
evidence
keeps
supporting this
returning to
first amended motion to
self-defense,
revoke
but legally,
unadjudicated probation.
that
to
argument
grant
had
it
to
by
be
a
made before
preponderance
he
of the
pleaded
evidence or
guilty to
greater,
the original charge.
as
Once he
allegations
accepted
1
responsibility and received
and 5
probation,
had,
that window largely closed.
yeah. All right, there is sufficient evidence supporting this first amended motion to revoke unadjudicated probation to grant it by a preponderance of the evidence or greater, as allegations 1 and 5 had, you have pleaded true to, and thus the motion is granted and your deferred or unadjudicated probation is hereby revoked. And you were represented by Mr. Dusler here, who I can guarantee you informs people how to proceed and has been doing this longer than I've been doing this in the practice of law. And he advises people, intelligently. There's no surprise here. There's never a surprise. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1, admitted to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this aggravated assault. And this involved the use of a deadly weapon, namely a firearm. And it states you pleaded guilty by shooting the firearm at the complainant, which she was shot several times. You were hereby found guilty of that offense. I now sentence you to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. A deadly weapon, namely a firearm, will be placed on the judgment, and it will be rendered affirmative finding on the judgment that that is found so based upon the evidence. You understand what has happened to us?
Yes, sir.
That is all. Don, what else do you have?